You're watching The Legal Breakdown. Glenn, you and I have spoken extensively about this ongoing effort by the DOJ to dismiss the charges against Eric Adams. Obviously, he had bribery charges levied against him. The DOJ is now seeing that he is useful in New York City to carry out these ICE operations, these deportation operations. So the court, not willing to just dismiss the charges outright, decided to bring in a court-appointed lawyer to argue the adversarial position against whether or not they should actually dismiss these charges as the DOJ wants to. We now have an announcement from this court-appointed lawyer. Can you explain what just happened?
Yeah, Brian, a really interesting and I think largely misunderstood development, but a big development today in the Eric Adams prosecution and DOJ's efforts to not just dismiss the case against Eric Adams, but to dismiss it only temporarily so they could hang it over his head to, make sure Eric Adams is a good little mayor and does exactly what Donald Trump wants him to do. So here's what just happened. There was an outside lawyer, Paul Clement is his name, a former solicitor general, very highly regarded, argued 100 cases before the Supreme Court when he was the solicitor general in the George W. Bush administration. And Judge Ho, the presiding judge, said, listen, right now, the Trump DOJ wants to dismiss this case temporarily. Eric Adams, the defendant, said, that's fine with me. Go ahead and dismiss it temporarily. So those two, the prosecutor and the defendant, are basically on the same side of this case. And there was nobody arguing the people's case, the public interest aspect of whether this case should be dismissed. And if so, should it be dismissed temporarily or permanently? Well, now we have the answer from the outside lawyer, Paul Clement, who just filed a 33-page brief in the case being presided over by Judge Ho. And he basically said, wait a minute, Judge Ho, something is not right here. If the Trump DOJ dismisses the case temporarily, it will be hanging over Eric Adams' head like the sword of Damocles. That's a quote from this new court filing. And basically, it will look like, the Trump administration can direct the mayor of New York City to do anything Donald Trump wants him to do. And that's just not right. So he said, okay, it should be dismissed because when DOJ decides not to prosecute a case, it's not like the court can just find another prosecutor or another agency and make them prosecute the case. So Clement said it should be dismissed, but it should be dismissed permanently with prejudice so DOJ can't hold it over the mayor's head to kind of make sure the mayor stays in line with Donald Trump's priorities. So, when you read headlines, and I'll tell you, Brian, this is what makes me happy that I decided to leave corporate media, legacy media, mainstream media, because when you read the headlines in USA Today and New York Times, it says, independent attorney says case should be dismissed against Eric Adams. That completely misses the point and misses the mark. The question here is whether it should be dismissed temporarily so it can still be used as leverage by Trump's DOJ, or whether the right thing to do is dismiss it permanently. That is what the import of this story is. The outside lawyer said, no, it should be dismissed permanently so it can't be misused by Trump's DOJ. Now, Judge Ho doesn't have to abide by that recommendation, but he will now consider it and he will decide what the next step is in the case in ruling on this DOJ motion to dismiss Eric Adams' case.
Just a quick note before we proceed, and that is that to your point about legacy media, mainstream media, Glenn and I are both 100% independent. Both of us did used to work with MSNBC. Both of us are now 100% independent, as I just mentioned. So for those who are watching, if you want to support independent news, especially as we're watching legacy media drop the ball on a daily basis now, please make sure to subscribe to both of our channels. Glenn is almost at 1 million subscribers, so if you haven't hit the subscribe button, go ahead and hit that subscribe button. Glenn, quick question. You had noted that this is really a matter of whether to dismiss with prejudice or without prejudice. And it is a good decision to dismiss with prejudice so that Trump can't continue dangling the prospect of prosecution over Eric Adams' head in perpetuity. But to your point about there being no vehicle to continue a prosecution if it was well-founded, which this prosecution was, why not just be able to appoint a special prosecutor if the DOJ isn't going to do its own job by prosecuting somebody who deserves prosecution?
Yeah, that's a great question, Brian. So first of all, this was a real rebuke to Donald Trump's DOJ when the recommendation is no, you can't do it the way Trump and his DOJ want to do it. But to your question, there is absolutely no vehicle, no mechanism, no lawful way for the co-equal branch of government, the judicial branch, a federal court judge, to say, I want my own prosecutor. I'm going to deny the Department of Justice's motion to dismiss. I'm going to pluck out some other prosecutor and drop them into this prosecution. Well, guess what? First of all, there is no legal mechanism to do that. And even if there was, that person would have to rely on all of the DOJ prosecutors to get the information, the evidence, the witnesses, the transcripts from the grand jury and everything else. It wouldn't even be feasible if there was a lawful mechanism, and there's not a lawful mechanism. But here is probably my favorite part of Paul Clement's 33-page brand new court filing. He drops an Easter egg in there. Let me set it up, because we have seen the Trump administration flirting with the notion that they're not going to obey court orders. And they're almost like goading the federal judges to go ahead and hold us in contempt. See how far that gets you. We're not there yet, but that sure seems to be the road that the Trump administration is on. They seem, Donald Trump seems to be spoiling to just plunge us into a true constitutional crisis. Well, really interestingly, Paul Clement, the outside lawyer, dropped on page 15 of this new court filing the following argument. And I'm just going to read a couple of sentences, and our viewers are going to understand instantly the import of these few sentences. Paul Clement writes, there is no express authorization for the courts, the judiciary, to take over a prosecution or to appoint a special prosecutor to maintain a prosecution that the executive branch, the Department of Justice, wishes to abandon. Here's the important part. But there is one narrow context in which the Supreme Court has recognized that a court has the authority to exercise what would otherwise be a core executive branch, DOJ, function. It is long settled that courts possess inherent authority to initiate contempt proceedings for disobedience to their orders, authority which necessarily encompasses the ability to appoint a private attorney to prosecute the contempt. Indeed, the Supreme Court has held that it is essential to ensuring that the judiciary has a means to vindicate its own authority without complete dependence on the other branches of government, like the Department of Justice. And if the judiciary were completely dependent on the executive branch, DOJ, to redress direct affronts to its authority, the court's authority, it would be powerless to protect itself if that branch, the DOJ, declined to prosecute. Brian, what are we learning there? We are learning that if Donald Trump and his administration continues on the road of defying court orders and is willing to be held in contempt, that is the one and only one instance where the judiciary, that separate co-equal branch of government, can get itself an independent prosecutor and can say to that prosecutor, now, try Trump administration officials for criminal contempt of court, because that's the only way the judiciary can deal with crimes committed against them, against their authority to issue lawful court orders. That was a surprise when I read it buried in the middle of this 33-page court filing.
And Glenn, I think it's worth noting too that Paul Clement isn't some liberal, right? This isn't like Rachel Maddow's producer coming forward and delivering this opinion. This guy has conservative bona fides.
Hardcore conservative bona fide, has argued many, many conservative positions. I would even call some of them hyper-conservative positions before the Supreme Court, which I think, blunts the criticism that will come from Trump that he's an angry Democrat, and that's why he told my DOJ that they can't dismiss it temporarily, they should dismiss it permanently. But I'll tell you, this is kind of firing a shot across the bow. And I would actually urge everybody to read. It's about 20 pages in substance, even though it's 33 pages long. It is an extremely well-crafted, persuasive legal filing that really is worth reading.
Do you think that it was done purposefully to put that little Easter egg in, basically saying that the only time it would be appropriate to appoint a special prosecutor is in the event that the administration opted not to comply with a court order? Because normally that's something that would never have presented itself, but we know now that this administration is in office, they have zero respect for the rule of law, and if there's a decision that's handed down that doesn't comport with their political ideology, they're perfectly content to try and discard it. And so do you think that that was done on purpose, and had a different administration been in office, he would have included that in the way that he included that here?
And it's a great question, Brian. I've asked myself that question, and here is where I land. That argument on page 15 was absolutely not necessary to make in connection with the issue that he was asked to weigh in on by Judge Ho, which is just, what should I do with this motion to dismiss? With prejudice, without prejudice, what are my options in your opinion? And here's how he, decided to include it. He said, listen, judges don't have the authority to appoint independent prosecutors if DOJ won't prosecute a case. And then he went one step further, which he didn't have to go. He said, the only time they do have that power is if people are in contempt of court, their court orders, and DOJ refuses to prosecute. It wasn't necessary. It was helpful context for for answering the questions that he was asked to answer by Judge Ho. So to answer, here's where I land, Brian. I think as a rule of law devotee, even if he has a very conservative background, Paul Clement decided to intentionally put that in there because he knows these are fights that are going to be had on the legal front in the weeks and months to come, as we are trying to see whether the rule of law and indeed whether our democracy survives what the Trump administration is trying to do to degrade, if not destroy, the rule of law. So I think it was an intentional inclusion to, help answer questions to come.
Well, to that point, again, we will continue to stay on top of any developments we see here, or to this idea that there might be a special prosecutor who needs to be appointed if the Trump administration does indeed decide not to comply with a court order. So for those who are watching, if you want to follow along, please make sure to subscribe. Again, I'll put the links to both of our channels right here on the screen. That is the best way to support our work and to support independent media more broadly. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.